Hi there, Martin Salvo from Salvo Migration. And in this video, I'm going to talk about the upcoming partner visa changes in November 2021 and why you shouldn't panic. So stay tuned. Hi, welcome back. So as we approach November 2021, the dreaded deadline, or what I would say the anticipated day or period that we are expecting the Australian government to finally implement the changes to the partner visa application process that they have been talking about for almost years now. It's becoming more and more common for people to reach out to us here at Salvo Migration and ask questions about the sponsorship changes. What are they? Who are they going to be affecting the most? What should couples be doing now in preparation for the changes? Are they actually coming in? So the purpose of this video really is to work through all those main topic points so that you and your partner can make an informed decision about whether or not you should be applying for your partner visa now or waiting until after the changes and applying a bit later in your timeline, perhaps when it's a little bit safer for you to bring forward the assessment of your relationship against the partner visa criteria. As a starting point, what I would like everyone to do that's watching this video is go and watch our other video on our YouTube channel, which is called Why You Should Never Rush an Australian Partner Visa, because that discussion or that topic, the point is equally relevant to the changes. Because on the one hand, you don't want to be rushing to apply for a partner visa because it means that that is the point in time that your relationship is assessed. Okay, so when your partner visa is applied for, that is when the Australian government is going to be looking at your relationship to assess you against the partner visa criteria. So inevitably what we're seeing is couples starting to stress, starting to freak out. They should be applying now before the changes, which actually could be detrimental to their application because maybe they're applying too soon. They haven't got their ducks in a row or have got their relationship facts and documents organized to be in a good position to apply for a partner visa and most importantly, meet the partner visa criteria. So let's get into what the proposed changes are. Firstly, the first change that we expect to come in is the shift, the switching of how you actually apply for a partner visa. So at the moment, at the time of recording this video, we can apply for partner visas and then apply for the Australian partner's sponsorship at the same time or just after. So there isn't a need to apply for sponsorship first. You can just apply for the partner visa and most importantly, get the bridging visa associated to that onshore application to the visa applicant. And then we apply for the sponsorship almost immediately after and we link the two and then they're assessed at the same time. The change that we expect to come in is that they're going to flip the order where we need to apply for sponsorship approval first before you can actually apply for the partner visa for the visa applicant. Now, logically, the people this could affect the most are those that are onshore in Australia on a visa that is expiring. Now, let's look into this a little bit more. Let's dive into this particular issue or what we're kind of considering, all the things that you want to be considering in assessing this particular component of the changes. Understand that partner visa processing averages these days is realistically anywhere from 3 to 6 months, and I'm being super conservative there. If your partner visa application is well prepared, well organized, and if the applicant and sponsor organize their police clearances in advance or shortly after lodgement, and if the visa applicant organizes their medicals shortly after lodgement, we are seeing that those types of front-loaded or decision-ready applications can be assessed in well under 3 months. If the sponsorship changes come in November, we're using that, I suppose, time frame average as a reference point. We know that the government are assessing complete visa applications, including the sponsorship of a sponsor, in 3 to 6 months. So let's apply that to what happens if they are only going to assess the sponsorship first before you can apply for a partner visa. Well, firstly, I have to assume that they're going to be able to get through these sponsorship applications in less than 3 to 6 months, because if they're able to assess complete partner visas, which is the entire relationship in that time frame, when they're just looking at the sponsorship, it really should be equal, if not much faster. So just use that as the reference point because that's a common question. How long is it going to take to get my partner's sponsorship approved? We don't know, but we're using that as our reference point at the moment. What are they going to be looking at when assessing my partner or me for sponsorship approval? Well, as far as we understand, what they're going to be looking at won't change to what they look at the moment. What they look at the moment for an Australian sponsor is, have they sponsored partners in the past? Have they sponsored more than 2 in the past? Or were they themselves sponsored for a partner visa within the last 5 years? That's what we call sponsorship limitations. And those are the 2 that we expect to be brought forward. So they're going to be looking at the Australian sponsors' previous sponsorship history to their previous partners, or if they themselves were sponsored for a partner visa. The other thing we expect them to be assessing is the character of the sponsor. Is the sponsor potentially a physical threat to the partner visa applicant? Could this partner visa applicant find themselves in a vulnerable or dangerous relationship in future based on the prior actions of the sponsor according to their prior criminal history or convictions for certain types of offences? Now, that is already in place. There's already kind of strict rules surrounding what previous offences and what type of criminal history will lead to the refusal of a sponsorship. The difference is that it's going to be assessed upfront when the sponsorship application is assessed. So one tip I can give you right now to anyone watching this video is, if you want to be at the front of the line to get your sponsorship application approved, if you're concerned about how long it's going to take, if your partner is here in Australia on a visa that's expiring, you're worried that after November it's going to take a very long time for you to be approved your sponsorship, for them to apply for their visa, then the first thing I can suggest for you to do is organize your police clearances. Organize your police clearances from any country you've lived in for 12 months or more in the last 10 years now, so that when the changes come into effect, if they do, you're in a position to provide them the police clearances, which is something they're very likely going to need. So you will differentiate your application from all the other sponsors that won't know to do that, where they're just going to be applying in completing the application form, that's about it. And then they're going to be requested to provide their police clearances, and that's going to take time. That's going to delay their applications. Whereas your application is going to have it upfront, meaning they can just process it and streamline your application. The second question we get in relation to the sponsorship approval process is there going to be a cost associated? At this point, we don't know. There isn't any definitive resource or announcement that I can point to that tells me conclusively that there's going to be a fee associated. But in other areas of migration law, there are similar pre-sponsorship approval applications that need to be submitted before you can apply for a partner visa. It exists in the family sponsored stream in certain parent visa types. It exists in the skilled stream for sponsored visa applications when employers sponsor employees or foreign workers. Now, generally, the ballpark figure for a sponsorship approval in those types of applications is around $400 to $500. So if there's going to be a fee associated, we expect it's probably going to be within that range. Who is really impacted by these proposed sponsorship changes? The most impacted type of couple that will be affected are those that are onshore, or where the applicant is onshore, because the main concern is the delay in the approval to apply for the visa to get the bridging visa. So if you are overseas with your partner, or if your partner is overseas, the applicant's overseas, and you're not pressed by a deadline, a time frame to apply for a visa to get a bridging visa, then this component of the change really doesn't affect you, as long as you don't have concerns around the character of the sponsor in your application, or the sponsor having sponsored partners previously in your application. I mean, assuming those things don't apply to you and you were just a bit concerned about how long these things are going to take, then realistically, if you're overseas, it's not anything you need to be worrying about right at this point in time, because we don't expect it to take too long. And given that we don't expect it to take too long, you're very unlikely to be impacted, given there isn't a deadline in your case. So therefore, the couples that are most affected at the moment, I would classify in 3 tiers: highly affected, mid-range affected, and low-range affected. If you are in the high-range affected, I would classify people that are onshore with a visa that is expiring within 1 to 2 months from, let's say, November. Assuming the changes come into effect on the 1st of November, which is speculation, then if your onshore visa is expiring by the 1st of January, so 2 months from the changes, then I would classify you as high risk, in the sense of potentially being impacted by how long the sponsorship approval process may take. The reality is that this is the first time that the government will be introducing a sponsorship pre-application or pre-approval process. Therefore, we ultimately have to expect there might be some teething problems Case officers may need to be trained in their new process internally. Department systems can fail. So we have to, I suppose, budget and make a plan for the possibility that there's a bit of a delay, initially at least, whilst they start preparing and assessing these applications. So if you're in that cohort, if you are classified as high risk under this definition, then as I said before, I would definitely encourage you or your sponsor to organize the police clearances for the sponsor. So at least when the time comes to be applying for the sponsorship approval, you have that you can attach immediately, and that should help to speed up the process on your end. If your visa expires from the 1st of November to, let's say, the 1st of April, so the next 3-month period, then I would classify you as mid-range risk, given that you have at least 2 months, if you're at the higher end of that spectrum in terms of the 1st of January your visa expires, you at least have 2 months there for the sponsorship approval to be granted, for you to be able to apply for your partner visa, to then get the bridging visa. And again, equally, I would recommend that if you're in that cohort of applicants or that cohort of couples, that you organize police clearances for the sponsor, so you're not caught out by any delays that might be in the system at that point. Or you might be in the low risk range of applicants, which is where your visa expires from the 1st of April onwards. So, 5 months after these proposed changes, potentially your visa is expiring. We would not expect the sponsorship approval process to take 5 months, given, like I said at the beginning of this video, the speed in which they are assessing complete partner visa applications at the moment. So if you fall in that cohort, then, do you need to be worrying about applying for police clearances? It's questionable. It's good to organize in advance anyway. They have a particular validity period for partner visas. And if you're looking to apply for a partner visa really within the next 12 months, it's worth organizing anyway. But do you absolutely need to? Probably not, because you're not likely to be caught out by any delay in the sponsorship application process. So to tie this back into, I suppose, one of the initial points that I raised, as we approach the November changes, couples need to weigh up. Firstly, couples need to determine if they fall in the low, medium, or high risk classifications. Because if you fall within the low risk classification, it's an equation of weighing up the benefits of applying before the changes. So removing all risk regarding the sponsorship taking too long to be approved for you to apply for the partner visa, versus applying for the partner visa potentially early in your timeline, and bringing forward the assessment of your relationship. So again, please watch the other video on our YouTube channel called Why You Should Never Rush an Australian Partner Visa. Understand everything that I talk about in that video, and then weigh up the pros and cons of getting the application in before the changes versus maybe waiting until the changes and applying later for your partner visa, increasing hopefully the likelihood of you getting your partner visa granted because you're delaying the assessment of your relationship later in your relationship timeline. This now brings me to the second proposed change that we expect to come in from November onwards, and that is the requirement for applicants and permanent resident sponsors to show that they have attempted to reach a certain level of English. Now, at the moment, we understand that the level of English that applicants and Australian permanent resident sponsors will need to be able to demonstrate is functional English, or at least that they have attended a minimum number of English language classes provided by the government free of charge. To clarify though, that is not required at the time of applying for a partner visa. That will affect all applicants for partner visas post the November changes, but it won't be something that needs to be met at the time of applying. Therefore, if you're concerned that you don't have the potential English language requirement satisfied now, or your sponsor has low levels of English now, that's not a problem. It won't prevent you from applying for a partner visa. It won't prevent you from getting a bridging visa. It won't affect you from getting the first stage partner visa application approved, because the requirement to meet that English language level is only at the time of being assessed against the permanent stage, the second stage of the combined partner visa application. As a quick summary, when you apply for an onshore partner visa or an offshore 309-100, you're actually making a combined application. And ordinarily what happens is that the department will approve the temporary visa first, and then 2 years from the combined application, the applicant becomes eligible for the permanent. Now, in that scenario, the couple, the applicant, and the permanent resident sponsor needs to meet the English language requirement at that point, 2 years after the initial combined application. Exactly what that looks like remains to be seen. Hopefully we'll have more information once the changes actually do come into effect. And that, folks, wraps up our video talking about the proposed partner visa changes for November 2021 and why you shouldn't panic. In simple, not everyone's going to be affected. Some couples are going to be affected more than others. And if you are going to be affected, there's ways to preempt that effect and try to speed up the application process for you guys by getting things organized in advance. My name is Martin Salvo, principal lawyer here at Salvo Migration. And if you haven't already, please subscribe, smash the like button, and I'll see you on the next video.